respect to violations of building and zoning codes, regulations for violations of codes, and county board members College and Rizzo had some proposals that are worth looking at and discussing. We don't want to pass anything here. We just want to discuss the pros and cons of this. And I want to bring to your attention that the proposed changes make reference to two other sections of the Code of Ordinances that I don't think you had a chance to look over before this meeting. So I asked staff to provide us hard copies of them. I want to bring your attention to sections 155-17.20 and sections 155-15-2010, which the hard copies will be here at the table. I want you all to each get those because when David and Steve are talking about them, they may lose these
Anybody else need them?
So I want you to have them. And this is why we don't want to pass anything here yet today, because we're going to continue this discussion next month in Judicial. And you'll get a chance to go over these two sections in the interim month, the intervening month.
Do you want to do roll call?
Oh, I'm sorry. You know what? That's right. I thought because it was a joint meeting that we already did that with the first meeting. We'll just make sure we haven't taken return that. So let's do that then. First, let's take the roll call. Karen, please.
Izzo?
Here.
Alec?
Here.
Freitag? Here. Garrett? Here. Grenier? Here. Weigel?
Here.
Howard? Cademick? Here. Guzalone?
Here.
Rice? Here. Weigel?
Here.
We have a...
Excellent. Okay.
We also have Republican Chair Jim Eustace. And State's Attorney Westcott.
Very
Digital. I guess that's it. Bruce is here. Nick Coleman. Okay.
All right. And Ms. Rice, would you lead us in the pledge?
I
Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Motion to approve. Yes. We don't have any minutes. We previously do it.
Yes, we
So
do.
we do. The second. All right. Second. All those in favor? Aye. Opposed? Nay? Okay. No nays? All right. Public comments? No public comments because there's no public. All right. Old business, which is what we are now on. Old new business. That's what we are on now, which is discussion of the statute of limitations proposal. All right, now we're up to speed. The statute of limitations, Mr. Izzo is going to give us a presentation of his proposed amendment to our code of ordinances on this. This should mean that, as you've heard throughout the course of last summer and fall, we've had numerous people come up and complain that they have had certain things on their properties, certain situations that have been there for years and years and years with no problems. And then suddenly they're cited and they feel that they've been treated unfairly. And some of the board members here feel that they have a point and thought that maybe we should address this matter. So Mr. Ballage felt that, he wanted to champion that cause, and he got together with Mr. Izzo and perhaps we should put this in writing and see where we're going to go with this. So Mr. Izzo did that. He's got some proposed language, and he makes reference to where he'd like to place that in our code of ordinances. So maybe I should just turn the floor over to you to explain what you read.
Thank you, Mr. Chairman. I think you can read probably what is best. I think the purpose of the ordinance is to try to provide some structure for these individuals who may be coming to non-compliance because of issues they've been on the property for years, sometimes more often than not assumed when they purchased the properties from a previous buyer. So I drafted a very simplistic ordinance at one point in time, and then had the opportunity to sit down with the land use department to talk a little bit about some of the concerns that they had and some of the suggestions they had regarding the proposed language. I think we all agreed at some point in time that we have to make this limitations turn into a situation where at least if there is a violation, it becomes a non-conforming use, so the land use department has some control over the premises going forward, or the non-conforming use going forward. What I didn't realize is when we first started doing this is that we have really two different types of issues we're talking about. We have building code violations, and then we have zoning violations as well. So what I'm trying to have is a discussion about having some type of a statute of limitations for both those issues, the building code violations as well as the zoning code violations as well. I got some great feedback from the land use department. That's why we drafted this initial language that you see that was provided previously. The only thing the land use department, I mean, they may have some other issues as well, but one of the issues that they have with the proposed language is my idea of having a statute of limitations based on a number of years, and the land use department having it based on a certain date. And to be brutally honest, I don't really know if I have a concern about that or not. I think the only concern I did have is if you put a specific date down, we'll have to look at the issue on an ongoing basis, because then the date becomes stale or we have to update it or whatever. And that's why I guess we should have that discussion on that particular issue. Lastly, I don't know if 3 years or 5 years or 10 years is the right thing. That's really for our discussion as well. And I'm open to any suggestions that this joint committee might have. So that's it.
I had a chance last night to look over some of the other portions of the code with respect to non-conformity. I thought it was kind of interesting how you were figuring this, where you pointed out that we could treat some of these violations of either the zoning or the building codes as non-conformities, that they would be designated as that. If they were designated as that they would be subject to being regulated under that section called non-conformities, which is this 155-15. And I thought it was interesting that there would be a mandatory regulation there that they would have to be maintaining safe and good repair, these non-conformities. And there was many different things in here describing what the nature of these non-conformities might be. It also talked about how these non-conformities would be what they would call running with the land, which is a term of art used in law. Basically, it just means that it's there. It's always going to be there unless you change the nature of this non-conforming use of this land by not using it that way anymore. And then it has to comply with that zoning regulation or that building regulation. And several other things I thought was an interesting way of dealing with a non-conformity. Over the next several weeks, when you get a chance to, board members, you might want to just read that section to see how this well thought out section of the code deals with non-conformities. And it might be an interesting way of dealing with these violations, regulations. I'm not saying you'll decide that this is what you want to do with it, but it is one possibility. And because I personally am of the philosophy that we've got rules for a reason, but also I know that sometimes there are exceptions to rules because circumstances can be extenuating. And when there are exceptions to the rules, I see that we do have ways of dealing with these non-conformities. So I would urge you to read the section. You've all got hard copies of it now.
I spoke with David yesterday, and he prepared a memo concerning this subject. I'd like to have him go through it and tell us what his opinion was concerning this discussion. You want to hand out your memo, Dave?
You can make it a copy.
It's about this subject.
While we're doing that, can I ask a question? What are we looking to achieve and what's the net gain? So, I mean, are we reducing the amount of ordinances, or are we just going to put a timeline on it, so that and I actually live in an unincorporated area, and then I was always told, I don't know if it's right or wrong, but like old barns on there and stuff like that, they all fell in there too, so therefore they're not covered by any zoning or whatever. So I mean, what is this going to do? I mean, if somebody has like a deck without a permit, then it's just going to relieve them of the responsibility of ever having to get a permit, I think.
I think what the purpose of the ordinance is to allow individuals some peace of mind knowing that if they do purchase property, for instance, where there is a non-conforming use going on at that time, it could be a setback issue, it could be a shed issue, or something along those lines. And if, say, for instance, it is a setback issue, they put a shed that shouldn't have been there. They bought the house, they've been there for 3 years, now they want to go get a deck. So they have to go to the land use department to get the deck. They take them out there and they go, you got a problem here. You're going to have to fix this problem, or whatever it might be. And they should be, and there should be a statute of limitations for that particular issue. That's what we're talking about. The one thing I forgot to add earlier is that even in my research, there are a lot of municipalities that have the same type of a statute of limitation. They fear, and I wish I could go to some legislative history, but there's really none on most municipalities. And to me, it's like anything else, like any statute of limitations. It just allows them, it's for people who have to worry about something happening 10, 15, 20 years from now. That's okay.
So currently now, if we purchase the property, and there's a non-conforming building on it, I go to get a permit for something else that they're actually going after. Is that on record now that they actually go after that?
They do. It's okay to say.
Would you like us to explain how?
Yeah,
Yeah.
that's what we're
Yeah, 'cause
here for.
I like to understand, 'cause I mean, where I live, I mean, you know, I probably have misconceptions.
Well, we can explain to you how such matters are dealt with. The proponent of the legislation will have to be the one to tell you why he thinks it's necessary. We have no idea. So he'll have to explain that. But David, how is this done presently when individual approaches the office requesting a building permit, and we are checking it for zoning compliance as a part of the process of issuing a building permit, and note some kind of non-conformity?
Currently, when an individual comes to the department, for instance, for a building permit, and we identify that there might be some site of deficiency or otherwise on the subject property, we will advise them of that, and if they leave the department and choose not to address it, that's the end of the matter unless there's a complaint to the subject property. Currently, under the way we currently operate as well, is that if a building permit is applied for on the subject property, and there are other outstanding issues on the property, for instance, you see the shed that's built on a permit, but the permit requesting is for addition of the house, we will advise them of that deficiency, the issue, that if there is a complaint on that, then we will have to address it, but we will not hold the permit on addition if they don't choose not to address that.
That's not the way I understand. When we had that situation in Homer, there's the exact opposite what happened. The individual was called out for a complaint on one thing, and 4 other things were brought up around. Not just the one thing that was brought up. And we've heard numerous descriptions of how, if things are in plain sight, that they would be cited for those things. Is that right, Kurt?
If there's
Am I
a
misunderstanding?
complaint.
Yeah, you're
Only if
talking
it's a
about a
complaint.
complaint, and he's talking about a permit. Those are 2 different things. Am I misunderstanding?
Permit causes a complaint if they go out there to inspect and they see the other violations.
Right, but the complaint is different than
But
permit.
you referenced Schroeder, that was in reference, and matters pertaining to that arose out of the original complaint. But what David has just shared with you, which is what he was asked to explain, was how this matter comes up when someone applies for a permit and we're trying to check for issues of non-conformity, what occurs. And we just told you what occurred. The case that you cite, Schroeder, was not a case, this was a case where an individual had not applied for a number of permits, which became evident attended to or following a situation where a complaint had been received on an unrelated matter, a matter that had no direct relationship to the matter of the number of structures constructed without a permit, but nevertheless, they were identified in the course of an investigation initiated by a complaint.
Well, this is exactly what we're trying to achieve here. If some crazy neighbor calls because you have they set a farm piece of equipment in his driveway, and then all of a sudden we go out to inspect that and find out that he's got a shed that's not where it's supposed to be, he shouldn't have to get fined on that if it was.
Well, I understand that I understand that that's the intent, and what it would be is under the general direction, as I understand it in this ordinance, is if the finding was that that shed that you referenced had been there for 3 years, then they'd be off the hook.
That's right. Mr. College.
Yeah, when you go back to the Schroeder case, I mean, I didn't bring all the cases, but I got about 4 or 5 cases that are similar to Schroeder, where they're called out, in Schroeder's case, they were called out for a farm tractor next to his house. They, if you go over there and look at the property, there's a farm in his backyard, there's a farm at the end of the block. So it's not that unusual for those people to see a farm tractor. But the zoning doesn't authorize it, so the complaint was made by a neighbor. All this stuff is stems from neighbors that are managed. So neighbor calls, they come out, then they found out that he had a pool that he replaced, was it 10 years ago or something like that? It was in the same deck, but the aerial photos show that it was a couple inches bigger. So he got fined for that. He had to fix that. He put windows in that didn't meet the energy requirement, and he didn't have permits. Then he had a shed. This was all found because of the farm tractor.
Let me ask you a question, David.
I go on with all this stuff, but the idea behind what my intent was similar to what they say. I thought we would, this is fine because we have to read all the stuff, but I figured we'd have a statute of limitations. I thought 2 years, Dave's 3, that's fine. But a statute of limitations that says, you know what, if you did something and it's not a life safety issue, leave the people alone. It's not hurting anybody. The only reason it was even brought to anyone's attention was because some neighbor's mad at somebody else. But it could have been there for 20 years. And with no statute of limitations, you're lying.
Okay, I got you. Mr. Musis and Mr. Rizzo.
I'm about non-conforming, conforming, and I would not give a blanket use of non-conforming. And I'll tell you why. I've dealt with a lot of these issues for many years. So now, Dave, you put a shed in and you put it in a drainage area, and you've been flooding people for years, and now you decide, you're going to sell your house, and we should just leave it there. No. I mean, some things actually need to come into conformance, and I'm going to, say, if you're in violation of something besides a setback, if you're in, a drainage area, or you've created a difficult situation, and it could be even, you're right up on your neighbor's property line with a shed, I don't know if that condition should be allowed to exist forever. I mean, I do think there's times when you can be reasonable and say, we're going to give you 18 months to come in conformance with this, but at some point, you do need an opportunity to correct the situation by telling people they have to come into conformance at some point in time. I'll give you a good example. And in our district, Dave, over Lincoln Estates, I had someone who put up a kennel in 1943. And that kennel was right on the property. They put it on their neighbor's property. And by the way, because there was no zoning ordinance at the time, the attorney's office told me they never had to come to conformance, ever. There was no rules at all. They had 90 dogs there. 90. Who literally, I think, put the neighbor in his grave. I mean, he said, I can't sleep, I can't do this, these dogs never shut up. So now, should that person never have to come to conformance after they sold the property? And by the way, the reason that it was allowed to exist is because the land use department at the time gave the buyer a letter saying they never had to come to conformance. So we wound up honoring it. But they should have been told, yeah, the rules that applied in 1947 don't apply today.
It was a long time ago, right?
Yeah, it was a long time. You know what? In 1947, I was just a thought. I wasn't even a thought.
But that land use letter was.
But my point is that to say, because you have a lot of condition, or nobody noticed the condition for a few years, that it never has to come into conformance. I think we need to rethink. There are situations where somebody may have to come into conformance. And I think a lot of these violations, especially like with sheds and so forth, people have put them in drainage areas, or they put them over utility easements, and they should. And so I think that if they're in a violation of something else besides just a simple setback or something, maybe you have to say, yeah, you have to come to conformance with that. Yeah, I would even say things like swimming pools. If it's a gross violation and you put it on your property line and you don't have it fenced in, and that does create a problem potentially for a neighbor. So I do think that we have to have a little leeway there. I don't think it should be allowed to go on forever.
Yeah, I know, Jim. I think, to answer your point, Jim, I think some of their concerns really are those life safety issues that we talk about. And that's not something I really want to make non-conforming. I think that's the. But the one
things like drainage, it's important.
I understand, but that could become a life safety issue too.
Yeah, that's true.
But I guess my question to Dave was this, because Dave made this comment. He said something about, he said, the way we currently operate, you say, if you go there for a deck and there's a non-conforming use, you'll just give them the permit for the deck and you'll overlook what's going on in the non-conforming side, right?
If there's an alleged violation, for instance, of a setback for a shed, we observe that on a plat, and they're in for a deck permit, we give them a deck permit, we advise them of that, so that there's no further action unless.
Do you find that?
But see, here, I think that what you're telling me, that you're talking about discretion at that point in time. Technically, somebody else can come back and say, you're in violation, we're going to cite you.
If we have a complaint on it,
Even without a complaint though, Dave, you have a violation of a setback. Under our ordinances, you are required to do what you need to do to cure that defect, correct? Am I right?
I didn't look at.
But no, it's not, but that's not my point. It's not a matter of operating, and I understand that I like discretion. I think that's a great thing in some respects. But somebody else could step in. Somebody else could step in and change that. They can operate differently, and that's what I'm trying to.
Well, that's certainly true, but, we've been asked repeatedly as this process has evolved in the past several months, is what do you do when you receive a complaint? And we've been describing that to you. And part of advising the person is, look, you've got a problem here that is technically not in conformance. We're advising you to take care of this situation. And if we haven't received a complaint on it, but if we receive a complaint, we're going to pursue it. Now, I think what I heard you say, Mr. Izzo, is that it's all very well and good, but you're saying that's the current practice, but at some future point, if the ordinance were to stay the same, and this technical violation were still to exist, some future administrators could choose to act in a different way and go after the matter at that point in time, and that's a matter of concern.
Correct.
Mr. Frizzle and then Mr. Mayor, please.
Yeah, two questions now, so I'm confused. We follow the law if we see something when we're there for another complaint, but we don't follow the law if we see something if we're there just for a permit. That confuses me, number one. But number two is, what my concern too is protecting the people that buy a house, that there's something that doesn't conform. I mean, the other end of the spectrum is maybe if you sell your house, you have to have an inspection to make sure that you're in conformance, because other than that, those people have no protection to say, I bought this house and I didn't realize it was a foot over whatever, and I have to move it now if somebody complains about it.
Let's talk about that a little bit. Of course, and again, we're just talking, we're exploring ideas and concerns, but and this is just meant to get the discussion going, I understand that, Mr. So just get into the discussion. Well, okay, but as it's currently drafted, this is applying not solely to situations where there's been a recent property transfer.
Right.
The person could have been there for 25 years, single ownership, didn't have a neighbor say anything before, but some new neighbor moves in and now they're saying something. So this is not solely about matters of property transfer. But, having said that, in case of property transfer, now this is not codified in the code currently, but David, could you talk about the procedure, the form that is sometimes brought to us that was drafted by the Bar Association and the Board of Realtors to try and protect a would-be buyer to know that the property that he's about to purchase is in conformance? Could you explain that process?
There's what is called, commonly known as a Rider 412, which Three Rivers Association of Realtors, and I believe there's a law firm that work together on this, that an individual will submit to the department for basically zoning disclosure. And depending upon what they do on that form, we'll review it and then provide them information as to conformance or non-conformance of the subject property to the local zone, to the zoning. Now, there are certain limitations on that because many times we don't get the plat survey. We don't have a snapshot of current conditions. We don't know all the current uses on there. So really what we're attesting to is what is the zoning of that property. If it's R3, we'll put it on the residential zone. And if we can identify certain deficiencies, we'll advise individuals. But basically we're telling them whether or not there's special use on the property, there's variance on the property, and whether or not that use is permitted in that zoning district. We're not going to be attesting to setbacks, approaches on easements, or things of that nature. It's not get to that level of detail.
Nor does it deal with any matter relating to, we're not attesting in any way that the property is, as it sits there right now, totally in conformance with every aspect of the building code. We're not saying that. But I simply wanted you to know that in terms of, the consumer protection thought, that a long time ago, the realtors did establish this. This is an extra legal process. This is not required. Every buyer might, if the real estate agent doesn't tell them that this opportunity even exists, they would be completely ignorant of it. But I simply want you to know that the private sector in the real estate community has recognized this concern a long time ago, so that they could be in a position to assure their client, the would-be purchaser, that there has at least been a trip to the zoning office to get the attestation as far as they described it.
Yeah,
So
but
back to my-
just in response to that, that's just protection for the buyer of a premises against the seller, okay? So, and that's a contractual agreement that they've entered into. So what happens if there is a zoning violation, I could, as a buyer, go against the seller, but if the seller is defunct, bankrupt, or out of town, I still have to deal with the zoning violation, correct?
That'd be correct.
So back to my original question. If we go out for a permit, we see a shed in the wrong place, then we look the other way. But if we go out because someone filed a complaint against an existing deck and we see the shed, then we file a complaint against the shed as well. Then we file a complaint against the shed as well. Is that right?
We are currently proceeding to just act on those things for which there has been a specific complaint.
Which is different than what we've been doing?
It's an adjustment in modification.
So we changed these issues.
It was important to say whatever was in plain sight was going to be cited.
Well, what I said was under law.
No, I'm
saying, I'm saying.
I'm going to keep naming all the names that you've got it to.
Well, if you'd let me speak, Mr. Balish, what I've said is that we have a clear legal right, and we still do, to address anything that we see that appears to be in non-conformance with the ordinance.
As well on a permit, this as well, right?
That is correct, as well as in terms of a response to the complaint.
Okay, Mr.
But-
Mayor and Mr. Howard, both of you.
Yeah, I do have 3 questions, and maybe a statement. When you see something that's not in compliance and you've not received a complaint, and you look the other way, is there a fine issue? You just advise them, right?
There's never a fine issued until such time as if we initiate a citation,
Okay.
and that citation is unresolved after the requisite period of time, and then it then goes to the administrative adjudication.
And
Then there's a hearing, and if the hearing officer decides, based upon the evidence presented to them, that a violation has in fact existed, they then at that time ask the county to recommend a fine, and then it's the decision of the hearing officer to impose the fine at that point in time.
very good. And if it's a life safety issue, and you've been called out to put up they're putting up a pool, and you see that the deck is like really, really bad, and somebody could get hurt, do you still look the other way, or do you initiate a complaint?
Now, give me the scenario.
You're coming out there for a pool.
Coming out there for a pool.
A permit
in-
for a pool,
Okay.
or a permit for a shed, I don't care, anything not attached to the house. But you
A
see
permit
that
has been applied for.
Right, and you see that the deck is in not so good shape. Do you just notify them, or do you then issue a citation?
We indicate to them that they have a problem that is in nonconformity with the ordinance, and we ask them to address it, but we don't go to a full citation unless and until there is a complaint specifically addressed to that matter.
But her
Yeah,
her caveat was a life safety issue.
Right, that's where I'm going. And so, let's say, if you see it and you say, wow, somebody walks onto that deck, it's gonna, the railings are gonna fall off, or the whole stair's gonna collapse, and you let them know.
Yeah.
Do we do any follow-up at all?
Well,
Because it is a life safety
Here's
situation.
the matter. The view, and I may ask our chief building official to chime in here.
Okay.
The entire premise of the entire building code has the origin of its legal rationale, the entirety of it, every dot and twiddle thereof, on the notion of the preservation of public health and safety. It does not, in the ordinance, have a separate section that says, these are mundane, trivial, nice to have, who cares, maybe it'd be good, maybe it wouldn't, oh, but these things really are life-threatening. It doesn't make that distinction.
Thank you.
And consequently, the thought is, well, isn't that left to administrative discretion? It really, truly is not. But of necessity, there are situations where if it really, truly appears as if it may cause imminent threat to health and safety, we will often consult with the state's attorney's office and get their legal counsel as to whether the nature of the situation rises to the level of what courts have defined as an imminent threat to health and safety. There is case law on that subject, Mary can speak to that. But in terms of our ordinance, there is no distinction about, oh, these are really important health and very important life safety issues, and these are just nice things to do.
So really, the key for you is somebody's made a complaint. So somebody makes a complaint, you issue a citation, it goes through the process. Somebody mentioned earlier about giving somebody 18 months. I don't know what you're talking about. Jim said it, 18 months. Are they given sufficient time to fix things, or, for things to be rectified?
Right. Recently we had a change in the manager of our code enforcement area. You sound like Montana, who you all know. Mike, could you speak to it? Could you speak to just a typical
Is that a voluntary
complaint?
complaint?
I think so.
A typical complaint where we've gone out and we found prima facie evidence that there's a violation of the building code. Just give the time frames that are offered prior to seek conformance prior to referring the matter to the administrative adjudication process.
Once a complaint is received, the inspectors have gone out and verified that that violation exists. The property owner will see a first notice of violation. And that notice gives them 21 days to correct the situation. After that 21-day period, we can forward the case to administrative adjudication or the state's attorney's office. Now, scheduling for administrative adjudication hearing or an appearance in OV court generally takes another 30 days. So you're looking at anywhere from 45 to 60 days before a judge or a hearing officer is going to rule on the matter.
But I'm old, and I don't have any kids around to fix my problem, and I'm broke, I'm on a fixed income. So to me, I mean, you're talking a timeline, I like the 18 months that Jim proposed. Can the administrative adjudication officer give them additional time before executing a fine?
They can.
Okay, so if they plead their case properly, they can get some leniency. I just want to say, I think our policy, from what I've read, and I'm going to read these 2 sections you gave me, is fine. I don't see a need to change our entire way of doing business to satisfy 3 or 4 complainers. I look at it to Congress making a law to keep that lady alive on a food machine down in Florida a few years ago, Terry Schiavo. I don't think we should legislate for a few people. If we're getting hordes of complaints, then I can see, yeah, we maybe need to make a change in our policy.
You've got a statute of limitations on leases.
This is different, though. That's robbing a bank, committing a crime against society.
You've got 30 years.
But Jackie, and to counter your argument, we're doing a burned ordinance because of a few people.
Yes, it's more and more people.
No, but I'm just saying though, it was a few people complaints, now we're doing a burned ordinance.
Okay, Mr. Howard, Mr.
But
Howard.
we recognize it.
Mr. Howard has the floor now.
Well, we recognize this is a health issue as well, because people are worried about having to fix things they don't have money for.
Okay, Mr. Howard's been waiting a long time now.
I'd like to make a comment, and I've made this comment before. It is unfortunately, we live in a society of rules and ordinances. I personally think, over the years, this is my personal opinion, that the county board created too many ordinances, okay? I mean, you can go south of us a little while, 10 minutes south of me or whatever, you have counties down there, you have townships. It's a different world, okay? Now, but I also understand that there's a population density increase in Will County, so we do need rules and ordinances. So I think the issue here today is either we want less rules and ordinances, or we stand behind our building department and say, you know what, we have these rules and ordinances, so we support you. You're the policeman, you're the bad person when it goes out there and the individual sees, and they don't like to see you when you come out there, but you enforce what we tell you to enforce. And we cannot selectively tell these people. We're giving them all mixed messages today. We're saying, you know what, we understand that's fine if you build a shed and it's there for over 3 years, that's going to be okay because you passed it, therefore you get a free pass. Mr. Moose has brought up about the dog kennel. Before, I'm sure when the dog kennel was built in 1947, he might have been the only resident next door to it. I don't know that, So what happens is this is evolving into something now more so than what I think that we can actually resolve here, unless you go back to the simple premise of, guess what, we don't need all these rules and ordinances. But I believe that we really do at the end of the day. And I'm the last guy that I want to admit that, but I do live in an unincorporated area. I have dealt with the building department, and I had found no problems with them. There's individuals out there next to me, not too far away from me, that basically called me because the building department says, look, your pool deck or whatever is incorrect, and they did find some other violations or whatever, but I found it very difficult as a board member to come to them and just basically present the problem to them in simple terms. But I can't advocate for that resident living next door to me saying, hey, I'm a wink and a nod, everything's going to be okay. That's not right, because we cannot tell our enforcement, our code officers that go out there in our building department that let's be selective in only what you do. And by the way, here's a message that we'll send out to our residents. If you did this, and if you can get by for 3 years, 5 years, or whatever it is, you're free. You got a free pass. So therefore, if I build a shed in my backyard, and I'll count the day, and I'll put on a calendar or whatever, then I'm going to say, you know what, 3 years and 1 day, forget it. I'm free. I'm clear. So I mean, that's the real premise here. I mean, either you want these ordinances or you don't want these ordinances. You cannot selectively enforce the ordinances.
Well, to cure that defect, pick up the suggestion by land use, make it a date certain. So at that point in time, it's almost like a grandfather clause in some respects.
We are grandfathered out there.
We're not limiting. We are not limiting the. Excuse me. 1 second. 1 second. We're not. I'm sorry. We're not limiting the ordinances that are there. All we're doing, we're not eliminating ordinances, but we're just putting in limitations as to when it can be enforced. That's it.
I was going to say something to what Bob was saying.
you know, all the laws and rules and regulations that we have in Will County are getting just like the cities. In Will County, we have to call and get a permit to replace a door, because your door's junky, there's a hole in it. You can't just go get another door and put it up there. What is it, 6 screws? You know, you gotta go get a permit, pay for that, and you got, you know, the whole bit. A window gets this leaking water, you gotta get a permit. There's a windstorm, part of your siding comes off, you gotta get a permit. People moved to Will County to get away from the municipal stupid rules, and now we're putting those same rules we're doing in Will County, where people left the city to come here to get free of that, and now we're saying we gotta do it because it's for your safety. Well, guess what? In my neighborhood, the people are losing their jobs on my block, so I ain't gonna tell them no, but look at their houses. They don't want to get permits to fix them because they're afraid they're going to have to do more stuff. So, hey, it's okay. We'll start living in a slum 20 years from now because no one has the money to fix their house.
Some of our staff from Land Use Development have some comments that they want to offer. But before I recognize them, I do want to give them a 2-minute warning here that we're going to be shutting this down.
Good.
But as you can see, there's a lot to be discussed here, and I do want to continue this next month at the Judicial Committee. We're not going to resolve anything today, but I think this is a good start. That we're putting this all out on the table, and we need to discuss this more. And we may decide that we don't want to do anything with this code, or we may decide that we do want to change something. But I appreciate the fact that Mr. Balch and Mr. Rizzo has put something on the table for us to be chewing over. This is something that we need to be talking about. And, but we can go another couple hours with this. You guys are probably interested in eating, and you've already been to one meeting. So having said that, David.
Yes, sure.
Not David, this is this end.
Oh!
I'm sorry.
Absolutely, Dave. Dave's not here. So,
I have to be downtown at 1 o'clock in Teamsters.
what I wanted to, something for the committee members to think about, is just, what I've been mulling through my mind is that there's 2 different discussions going on here. One of them is basically an enforcement matter, how procedures, how things are enforced. But when you're looking at the zoning ordinance, I kind of separate out the nonconformities that we've been talking about, is that you actually need to look at the nonconforming section of the ordinance. And it's not an enforcement issue, it's a determination by the board as to whether or not they want to identify certain uses, structures, development features, even parcels or lots of record as non-conforming status, meaning legally established, but subject to certain parameters within the zoning ordinance. And it's a very complex issue, obviously, because we're talking about it so much here. But one thing to consider is, separating that out is truly a land use issue, it's a zoning ordinance issue, and I'm not getting into the building code, but letting the Land Use Development Committee deal with that matter away from the enforcement procedures and policies. I mean, looking at it through the view of the zoning ordinance and a non-conforming section. And historically, it's the Land Use Development Committee that's done that. We're doing it, as we did today with medical cannabis. We'll be doing it coming up with cleaning up, on a 1-year, actually it's going to be 1 in 6 months. Look at the zoning ordinance, trying to see what, with the revision, what problems are dealing with those matters. So that being said, there's also things that the board needs to consider. The draft text is now, again, it's a starting point. Only deals with structures and development features. It doesn't deal with existing lots or parcels, and doesn't deal with uses as well. And is it the intent of the board to go beyond that and deal with those lots and uses? It doesn't deal with the building code, which again is another matter. And you have to think about too, the 3-year date versus a date certain or fixed using aerial photography with visual evidence to determine whether or not something was there or not. I know McHenry County right now is looking at the same situation, same issues, going back, and they're setting a window about, I think it's about 10 or 11 years in the past, and it will be their benchmark using aerial photography. Also too, the ramifications on assessed valuations and property tax revenue. There's no permits being issued for certain things. Those aren't going to be on tax rolls. And then finally too, which is even more important, we talked about medical cannabis, is reviewed by the state's attorney's office from their perspective, legal perspective, what is really So, I mean, those are some initial comments. I know there's a lot to think about today. But, you know, my recommendation is to kind of excise out the non-conforming matter with the text changes to the zoning. It's not pleased.
I was noticing in that one statute too, on non-conformity structures, non-conformance, the valuation section on that, thought that was interesting too, was 3 times the equity value being assessed on it and for property tax purposes. And I hadn't even thought about that aspect of this whole thing too. So I'm glad you pointed that out. And great.
Mr. Chair, I would just like to brief the committee, joint committee, on various things. I know that our board member Violet just brought up things as windows and doors. There are some things that codes cannot address, and that is what Illinois makes state law. Illinois has made energy conservation state law. They've taken the 2012 International Energy Code and made it a state law. If the builders do not come in and if they don't meet the U factors on windows, the resistance factors on doors, the leakage, the person on the end result, who our consumers are, can actually sue that builder and sue us if we don't do this properly, because then we're aware. Radon is a law in Illinois. Accessibility is a law in Illinois. They are no longer codes. So that window, that door, that bit of siding that's not wind barrier, that's not insulated, becomes something that we have to address. And believe me, I have 1 plumbing inspector and 1 partial plumbing inspector. I have 2 building inspectors, and we cover 846 square miles every day, and we get it done. And to go out in just a window or a door does not make our job any easier. We put our boots on, we change our clothes, we do what we have to do to get the job done, and we'll continue to do that. But believe me, sometimes we would rather not have to do other things as well, but we're required by state law to do so.
I have a question for the state's attorney. When I talked with the attorneys from the state capital development board, they told me that the state has no mechanism and no desire to enforce any kind of code violations at all on the county. So if the county decides that they don't want any code, or they want just part of a code, the state will not enforce it. I want to know if that's a fact.
Well, the state tends not to enforce anything against the county. I guess that's a...
What I'm trying to get at is if they're not going to enforce it, it's like with the medical cannabis. They're turning their head and saying, forget about it. We ain't going to worry. Ain't going to have... Well, I'm saying the same thing. Like the energy code is a silly code. It's costing tons and tons of dollars. And so what if we say, guess what? We're not going to enforce it here either.
I am never going to render an opinion to say ignore the law. That's never going to happen.
I just wanted to say to Bob, if you have a shed that's not conforming, you better hope the neighbor doesn't complain, because it's not conforming.
Let me ask a question for clarification. For real, the barns, I built my barns years ago, like back in the 80s, and then you didn't have to get a building permit. No, back then. I remember that, am I correct?
You were agriculture.
Right?
Permits were instituted. If you were agriculture, you were agriculturally exempt. You still don't apply for agriculture.
Yes, you do, but you still got to get a permit.
The permits come at no cost. They provide.
Hold on, guys.
Chairman Weigel.
Wait,
It's a free permit.
Mr. Howard's in the middle of asking.
Okay.
I think we should go along with Dave's recommendation and refer this matter to the land use department rather than the council. So I make that motion.
Okay, we have a motion. I don't think everybody heard it.
I kind of disagree with Tom. I think it should stay with this because, you know what? This is a bigger group. We'll get more ideas. We'll get a better thing that'll pass the board. If we go to land use, it's going to get over there, and then it goes to the full county board, and it has been thoroughly thought out as with this large number. So my opinion is no. I would vote no.
Land use are the experts.
Well, none of us are experts. They put me on this committee when I got elected. I could have been put on your committee. What's the difference? I'm not no expert on either one.
Will you state the question or motion again?
That we refer this topic to the land use committee rather than the joint committee of the judicial.
Okay, there's been a motion placed on the floor to refer the matter of amending the code of ordinances to the land use committee rather than judicial. Do we have a second on that motion?
I second it. Let's do an up or down vote on it, so.
Okay, those in
That way
favor?
Steve's going to chance.
Those in favor, indicate by saying aye.
Aye.
Those opposed?
No.
I think I need a hand on this one. Those in favor, please indicate by raising your hand.
Can we call the roll?
Call the roll.
Oh, call, okay. Those in favor, we'll take a roll call.
Izzo?
No.
Balich?
No.
Freitag?
No.
Harris?
Yes.
Trainier is not here. Bible? Can we come back?
Yes.
Yes?
Yes.
Howard?
I'm going to abstain.
God bless you, Bob.
Siselo?
Yes.
Rice?
Yes.
And Wyman?
Yes.
6.
You can't go through life abstaining.
We have 6 to 3. It goes forward to land use.
Okay.
Well, I would assume, even if it's moved forward to land use, the opportunity to have discussions with members who are not on that board. I just can't vote.
Yes.
Yeah, I think because Reagan Freitag's on that committee, and I'm on that committee.
We have honorary members in that.
So, yeah.
Mr. Balloch is there.
He's honorary.
I'm at every meeting.
We invite everybody.
Yeah.
I don't miss any meeting.
This is going to certainly
I'm
be
not on
a
that committee.
land use. Okay, well, some people have already left this, I'm supposed to be on the road to Springfield right now myself. So I'm open to entertaining a motion to adjourn. Second. Okay, those in favor? Aye. Okay. Well, thank you so much, everybody.